I'll be honest with you, Council. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one. Court calls the case of the people versus Marquesi Hankey.
Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, 713.
All right, it's your motion.
I did file a motion to state that previous PCC hearing, my client's bond vote from privileges from the jail suspended due to allegations that he cut off his tether and contact with the complainant. Following that particular bond hearing, I instructed my client to not contact the complainant witness, period, in the jail. Also instructed my client that if allowed to be back on bond, we would ask the court to hopefully just reinstate his original bond with tether. I would note, Judge, that he has no prior criminal, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts. Obviously, people address this. Some of the language that was used during conversations, I don't have phone conversations myself, but I will admit, Judge, that it seems as if my client had contact with the complainant even after his bond. And so I say this, Judge, and again, I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah, he is.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something it means. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier bond that he was able to post to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So, Judge, I am asking the court to reinstate his bond, and if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he's never had any contact with his family, his children? He hasn't been able to contact his dad, caretaker for. And so, at the very least, the restriction of his phone privileges to contact family.
All right, Bill, before I hear from the people, Council, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
My understanding, Judge, I thought community corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order. I'll be honest with you, Council. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to, because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on a motion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world's stopping me from you. I don't give a fuck what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then Why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continually, flagrantly calling the victim on other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly if you're gonna look at this judge and think I can't do something, young man, you're gonna learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but yeah, well, it's close, but I did pretty good. I said it okay, right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad or praised by my child. I can't say that I'm not in here for nothing. You obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here. I really don't. Truly. Again, please show mercy. Please.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, PCC.
Yes, sir. Is all discovery complete?
And I would ask if possible, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge Perry.
I did want to make the court aware, I did contact the jail yesterday and they have blocked both of victims' new numbers and old numbers, so there should not be any more
Calls coming through. All right. Thank you.
Thank you very much.
Thank you, Your Honor.
I said messed. I did. I thought I did pretty good. I thought I did. I paused. I said messed. And then went on. See? Aren't you proud of me?
I'm proud every day.
You know, a little bit more sincerity in that. That'd be good. All right.
Are you bringing the defendants out or are they going into?
They are up, which means we have to redo something here. Because counsel, you guys have to give argument. I've got 3 defendants. Yeah. Pardon? Yeah, we're gonna have to, why don't we add?
I can move to the jury.
Well, no, we can't do that because I got 3. So what I'm thinking is, can you guys play nice? Can you guys share the jury box?
I suppose.
All right. So,
Not guilty.
all right. I'd have to have you come to the podium to make argument, but we're gonna rearrange things so that we can get all 3 out of it. All right, court's gonna stand in recess while they do that.
All right.
Yeah, Michael Scott Allison.
All right. No, I'll wait. It wasn't really serious. Go ahead.
So we are just requesting a 2-week adjournment.
Really, all that for that?
Yeah, we're discussing a potential for a misdemeanor resolution, and I had spoke to Mr. Blondie this morning, who was just updating Mr. Collinson about that. He would also like me to respond at this time, if Your Honor will.
April 3rd, 2025, 9 a.m. As to bond?
President, may I address you personally about that? Please.
No, you can, but usually when people have attorneys, they don't do that because it doesn't really work out real well. But go ahead, say what you got to
I
say.
just never got to talk to my attorney before this.
Your Honor, on July 31st, you gave me a chance, you put me on probation,
Oh, I remember.
and you told me never to give up. Ever since then, I have been compliant with probation. I have been part of the Pathways of Recovery program. I'm very involved in the recovery program out here. I'm actually from Wayne County, but since probation, I've been out here. I'm in recovery every day, and the $100 bond is just something I wasn't able to get out of the Western Union with my lockup, and I would really benefit from a personal bond. I never got to talk to my.
Your Honor, I will just say, Mr. Conson has bond, set at $1,000, 10% on this case, and $100 on, his other Washington County case. He does have, a couple of holds on him. I'm not sure if they're holds that would, result in him actually being kicked out. I believe some of them may just be traffic related. But if Your Honor would consider maybe lowering the bond, to $100, 10%, just so it's something that he could afford to post, and, if
The other one was $100 personal bond. Yeah, it was a personal bond.
Your Honor, you consider amending the bond to a lower amount or granting Mr. Collins a personal 5% bond.
Response.
So it does appear that in October of 2023, the defendant had been charged with possession of methamphetamine, and we allowed him to plea to use. I think that's the case he's referring to that he was put on probation for. In this matter, police had contact with him on March 8th, 2025. He was found to be, I believe, in possession or to have illegally used someone else's credit card. A substance was found on him, and we just got the lab report back that came positive for match. And he gave a fake name to the police officers. So I actually think the bond is extremely low. We originally asked for a $25,000 surety bond, and I think he has 5 holds. So I frankly think the bond has been set extremely favorable to the defendant.
And Your Honor, I do agree that he does have 5.
He has 5 holes.
5.
Oh,
Yes.
5,
Again,
like
several
crab
other-
5
Right, exactly like that. Yes.
or Michigan seating.
Exactly.
Okay.
Yes, Your Honor.
Okay.
That's fine.
Several
Um,
other- and
Yeah, the name he gave when he had contact with Officer Stinky from Ann Arbor, I believe was Jacob Collins.
Motion for bond reduction is denied. Bond will continue. Thank you.
thank you.
Courthouse case, People versus Yusuf Jama.
Defender Hannah Appleton on behalf of Mr. John. Mr. John, will you see me for the record?
Thank you.
Your Honor, we're asking for an adjournment. There is some mitigation and some information that we can discuss.
Got it. 17, would that be enough time? Are you gonna do a are you trying to do a mitigation
We're not doing a
report?
formal mitigation.
Okay.
Just 2 weeks.
2 weeks, I got you.
Yes.
Okay, misunderstood.
And then if I may address bond.
Briefly, April 3rd, 2025, 9 a.m. Travel class conference. Go ahead.
Your Honor, on the new matter 25F20313, my record indicates he has a $5,000 bond with a 10% privilege. But bond is denied on the 1679 case, which is substance possession. He failed to appear previously for that, and that's why a warrant was issued and why the bond was denied on that. Mr. Jama is asking for consideration for a release on a tether and a referral to outpatient treatment at community corrections. He does it.
Just so that we're clear, he violated his community corrections release and then also failed to appear. So there are 2 things, but go ahead.
Correct. Yes, Mr. Jama is forthcoming about his substance use issues. He's asking for some support and referral to outpatient treatment. He is enrolled in a methadone clinic. He does have support of his family in the community. He does work as a dispatcher for a trucking company. So he's asking for consideration. or not necessarily a personal bond, but potentially a similar bond, $5,000 or 10%.
And Your Honor, the reason he came back into custody is the new case, which is an R&O causing injury. So I'm gonna ask that his bond continuous tonight.
Anything else? Motion for bond reduction denied. Bond will continue. Stated in both cases. Thank you. Court calls case of the people versus Fleming Davis.
Mr. Davis, could you just say the full name?
Lord.
Your Honor, we are asking for a 3-week adjournment to continue negotiations with the people. And I have also made a referral to our social work division for Mr. Davis.
Probable cause conference will be adjourned April 10th, 2025, 9 a.m. Bond continued. Thank you, sir. Oh, okay. Court does call the case of the people versus Anthony Taylor.
Good afternoon, Your Honor. People. Hey, Your Honor. Good afternoon. James Vitelski appearing on behalf of Mr. Taylor, who is approaching.
Yes.
Please state your name. Good. Anthony Taylor.
This is your motion. Go ahead.
Your Honor, we are asking the court to modify what is currently a $300,000 cash or surety bond. As I've outlined pretty extensively in my motion, Mr. Taylor has no prior convictions and, of course, then we have no prior violent history or history of absconding or not showing court hearings. He served honorably in the Marine Corps in his younger adult years and was honorably discharged. He also graduated from Eastern Michigan University back in 2006, I believe it was, with a bachelor's in business and computer science, and has worked in the IT security field for 20-some years. This is a gentleman who has never had any issues with the law outside of the accusations made in this case, which, with reference to what the people have articulated in their response, I would just note that even assuming there's some truth to these allegations, we dispute and we'll put our defense forward as we can through this process. There's no allegations of any sort of violence or behavior that would, especially when these children now are under the family court jurisdiction and also being supervised by DHHS, I assume, because of the CPS termination case that's pending. My client will not be anywhere near these kids without there being some kind of arrangements for supervised visits, which I think is highly unlikely until this case is fully litigated. Lastly, I spoke to my client's mother. Her name is Mary, and I believe she's 78 years old, lives in Belleville on the home where he was raised, along with 9 other siblings. She sounds like a wonderful, very religious woman who told me that she has relied on his assistance at the house. He could live there with her. He could be placed on house arrest there. And I'm not exactly sure where the children's mother lives, but I think it's somewhere in Ann Arbor. So Belleville from Ann Arbor is a significant distance. And again, the kids would be under their mom's her custody. And I think a significantly lower cash 10% bond with strict conditions like house arrest and GPS tether would be certainly sufficient in the broader context within which Mr. Taylor appears to this court. So I'm asking the court to consider a reduction to $100,000, 10% with either house arrest, GPS tether, any other conditions the court needs. And if the court even wanted to have his mother appear in court, she's a lovely lady, and I'm sure she'd be able to verify that she would keep him accountable at her residence where he would also be able to help.
Response.
This time, there are the people with objecting modification of bond who actually asked this court to deny the defendant's bond. As I know, this court is abundantly aware, Michigan Court Rule 6.106B1B allows this court to deny pretrial release to defendant charged with criminal sexual conduct in the first degree if the court finds that proof of the defendant's guilt is evident or the presumption of rape, unless the court finds by clear and convincing evidence the defendant is not likely to present a danger to any other person. like to direct the court's attention to page 7 of my response to the defendant's motion, specifically the allegations substantiating the charge of criminal sexual conduct in the first degree was provided by the minor victim, the defendant's daughter, during a forensic interview at the WCAC, in which she stated that on one occasion, the defendant, she asked the defendant what he was doing, to which he responded, just covering up. The minor victim then disclosed the defendant was touching her vagina with either his head or his hands, and that she believed that her father was either licking or blowing on her vagina. It was unsure if anything was inserted into her vagina, because it substantiates the charge of criminal sexual conduct in the first degree. Additionally, Your Honor, I don't believe that there's anything within the defense motion to substantiate a claim that the defendant is neither a danger to the community or is not playing risk at this time.
Briefly, Your Honor, I think with regard to CSC 1 accusation, the last statement that counsel read off, according to the forensic interview, she was unsure if anything was inserted. There may be stronger evidence for a CSC 2, but in terms of bond not being permitted on CSC 1, that's like a murder 2 or murder 1 charge. I just don't think it is abundantly clear that the evidence substantiates that.
Yeah, but your argument fails to take into account what will constitute penetration on a CSC.
Well, I understand that at least under the law, any penetration, no matter how slight, can be sufficient for a CSC 1 conviction. But this is a case where I believe that was the sum and substance of her statement in terms of the CSC 1 charge. And I don't believe there's any other evidence that would otherwise either corroborate or help prove that in any fashion, like forensic evidence. So we may well be having a trial ultimately on CSC 2 charges, but we
Why? I don't understand that argument. I don't understand that argument.
Well, whether or not there's a probable cause for a bind over on a CSC 1 charge will be determined at some future date.
Yeah, but again, your argument has a problem. Your argument has a problem in the sense that if the question's asked or what is said is, was anything inserted, that in and of itself can be a certain statement. That doesn't mean that there wasn't a CSC 1 if there is other penetration.
There may be evidence of allegations of contact, but I don't believe, from what I've seen so far, there's evidence of penetration.
I think the case law, as I read it, based upon what this individual is saying, would constitute penetration. No, I don't need them. I know what they say. I mean, and so then the question becomes on that CSC 1, if that is testified to, what's been stated, that could constitute a CSC 1. And it would seem to me that if this witness gets up there and says that, it is a great likelihood that this defendant would be convicted. I'm not saying he will be, but I'm just saying that's not what I have to decide as to whether or not he will be at this time.
And all I can say at this stage is we have not had testimony. There has not been the process of cross-examination to get clarity on what she meant by what she said. So that will be our next stage in this process. I would just ask the court.
So why wouldn't I, under the court rule, given what has been presented to the court, actually change his bond and deny it at this point?
Because I don't think that the evidence is abundant, or it's so clear that there could be a reasonable question to be decided at preliminary exam as to whether or not the CSC 1.
So why wouldn't I deny his bond at this point, let the exam happen, and then whoever has it revisit the bond? But based upon what's in front of me at this point, why wouldn't I just deny his bond?
Well, I think certainly the court would be within its right to do so, and I understand that certainly is a way these cases are handled in many situations. I just think that there's a lot of compelling reasons why a bond reduction would be appropriate, given the safeguards the court can put in place, even bearing in mind the context of the allegations of the situation. Not a random stranger, he's never had a history of just going out there violently attacking them. I understand what the allegations are.
Yeah, but I don't need all of, I understand what you're saying, but I don't need all of that under the court rule, right?
I think that it's still, these are still factors for the court to weigh out to determine whether or not the no bond or some other bond is appropriate. Because I personally don't think that the no bond portion of the court rule applies, given the facts as we know them. This is not such an abundantly strong case that there may not be a reasonable dispute or a reasonable issue, at least at preliminary exam and subsequently at trial, even if it is found. So from my vantage point, I still think there are reasons to look at all the factors.
Anything else from the people? Well, Mr. Rafetsky, if I do that, is there anything, if I deny his bond, is there anything or consider denying his bond? I mean, the one thing is that the court would then have to find that he's not a flight risk. But that almost shifts it. I mean, so tell me why he would not be a flight risk.
Well, I don't think he has really anywhere to go or any other motivating people or places that he would go to, especially given the fact that he's always loved his kids. After divorce, they had a 50% custody arrangement. So working through these processes in the legal system and being close to family like his mother and siblings who are in Southeast Michigan, he wouldn't have anywhere to go besides probably Southeast Michigan. And if the court wanted a passport, if he has one, surrender that. And again, I think a house arrest would be significant, especially at these early stages for the court to be confident in his appearance and in safety.
Right, I probably should deny the defendant's bond. I'm not going to do that at this point in time. I'll let it certainly proceed to preliminary examination if the people wish to raise that at an additional time, and certainly the court would consider that. But I certainly am not at this point going to reduce the defendant's bond. Defendant's bond, motion for bond reduction is denied. Bond will continue as it's set. Thank you.
Thank you, Your Honor. And on the PCC part of this, we're asking for an adjournment. There's still some discovery we're waiting on, so can we have the date in 2 weeks?
Probable cause conference, April 3rd, 2025, 9 a.m.
Thank you.
Thank you.
Thank you, Your Honor.
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, sir. Yes, sir.
In all of these cases, well, let's do it this way. In the case ending 779, the court accepts the defendant's pleas. 2 counts 3 and 4 counts 1 and 2 are dismissed. In the case ending in 5152, court accepts the defendant's pleas to counts 2 and 3, dismisses count 1, and in the remaining matter ending in 5189, the court also accepts the defendant's pleas of no contest to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and reports are ordered in all of these cases at the respective courts. Sentencing in the, you gave it to me here. Sentencing in the case ending in 779 before Judge Barr will be April 15th, 2025 at 10 a.m. And like I said before Judge Barr, her bond will continue on that matter. In the case before Judge Valvo, that's the case ending in 5152, sentencing will be April 15th also at 9 a.m. before Judge Valvo. Bond in that case will continue. In the remaining matter, 5189, sentencing will be April 18th, 2025, 10 a.m. before Judge Perry, and bond continues in that case. All right. Thank you. Thank you, Johnson. All right. Take care. All right. Bye-bye. Court calls the case People versus Jaden Marks.
Ready, Your Honor. Joseph been on the clear.
And Your Honor, Joe Simon on behalf of Mr. Mark Simpson.
On the chain of command.
All right, very good. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Plea form indicates that defendant would be pleading guilty to 2 charges. First charge is operating while visibly impaired. That's an added count 3, the 93-day misdemeanor, and also an added count 4 of transporting or possessing a firearm in a motor vehicle, the 90-day offense. In this case, there is also, and counts 1 and 2 would be dismissed. There's also a sentence agreement. I don't know what this is saying.
Your Honor, I apologize for my handwriting. It should indicate.
That's handwriting? No, go ahead.
It's my gun forfeiture, gun safety class, conditions for the court. People would not recommend upfront jail time as part of the sentence. And there is an agreement between the parties.
That would be extended height as count.
It's count 4 only, yeah.
Can't get it.
Right. Okay. Good. May I have it for?
You solemnly swear to affirm the testimony about guilty, the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Jaden Mark.
All right, sir, it is this court's understanding that you're going to plead guilty to 2 misdemeanor offenses. Is that your understanding?
Yes, Your Honor.
The first is the added count 3 of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Yes, sir.
The added count 4, transporting a firearm in a motor vehicle. That is also a misdemeanor punishable by up to 90 days in jail and a $100 fine plus court costs and mandatory forfeiture of the firearm and or device. You understand that?
Yes, sir.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes, sir.
To the charge of operating while visibly impaired, how do you plead? To the charge of transporting or possessing a firearm in a motor vehicle, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights? Please look at paragraph 5. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
November 24th, 2024, at the location of Washington Avenue and Grant Drive in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle? Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
The majority of a fight.
Were you stopped by the police or was there an accident?
Stop.
Why'd they stop you? All right. You're not disputing the right of the police to stop you in this case, are you?
No.
Were you ultimately arrested?
Yes.
Were you taken to the police station or hospital?
The hospital first thing.
They did a blood draw?
Yes.
What were the results of the blood draw?
Points 149.
0.149. Do you have any reason to dispute those blood test results? Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
All right. Did you have a firearm in the vehicle?
Yes.
Where was it located? Here's a bag where?
Oh, the passenger seat.
On the passenger seat?
Yeah.
Okay. Was it loaded?
Yes.
All right. Do you have any authority to carry a firearm in that fashion?
At that time.
He was pending approval for his CPL. He actually got it about a month later.
All right, but at that time, you did not have the authority to carry that. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, you have.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation is ordered. Sentencing in this matter will be April 30th, 2025. What time? 12 noon, or as your invite indicates, and that's before me. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Patrick Conley.
Mr. Long for the people.
Oh, I'm so sorry. It's in front of me.
Yes, it is.
Apologies, Your Honor. At least I'm in the room. Assistant Public Defender Jay on behalf of Mr. Conley. Mr. Conley, statement for the record again. Patrick Conley.
All right.
And Your Honor.
The court should be in receipt of plea form, not yet. Take them guessing into it.
All right, you guys are gonna have to get this plea form into us earlier. I don't,
I'm sorry, Your Honor. I was trying to get them in earlier. I apologize. Your Honor, the defendant's going to be pleading to enact count 5 of use of a controlled substance to it cocaine and the currently charged count 2 operation of a motor vehicle without security. In exchange for pleas to those 2 misdemeanors, count 1 possession of controlled substance to it cocaine, count 3 and count 4 will be dismissed.
is that a correct statement, Mr. Billender?
Yes, Your Honor.
May I have him sworn?
Right hand. You solemnly swear to affirm the testimony about the truth, the whole truth, about the truth.
Yes, sir.
State your name.
Patrick Conley.
Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
Yes, sir, it is.
The first is that of use of a controlled substance, that being cocaine. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court cost. Do you understand that?
Yes, sir, I do.
It's also this court's understanding that you're going to be pleading guilty to the stated count 2 of operating a motor vehicle without security. That's a misdemeanor punishable by up to not more than 1 year in jail and not less than $200 nor more than $500 fine plus court costs. You understand that?
Yes, sir, I do.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir, I do.
Understanding all of that, you still wish to plead guilty.
Yes, sir, I do.
To the charge of use of a controlled substance, how do you plead?
Guilty.
To the charge of operating a motor vehicle without security, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form.
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty in this case, you'll be giving up, waiving or giving up those rights as well as all the rights contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Yes, sir.
Were you on probation or parole at the time of this offense?
No, sir.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
Doing this voluntarily
Yes, sir.
of your own free will?
Yes, sir.
And because you believe that you're guilty of these offenses?
Yes, sir.
January 12th, 2024, at the location of Evelyn Avenue, Hull Street, Ypsilanti Township, Washtenaw County, State of Michigan. Were you in possession of cocaine?
Yes, sir.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes, sir.
And were you at some point also at that location operating a motor vehicle?
Yes, sir.
Did you have proper security or insurance on that vehicle?
No, sir, I didn't.
All right, counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
People satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2 and 5. Counts 2 and 5. Counts 1, 3, and 4 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
April 17th at 10 a.m. before Judge Washington.
April 17, 2025, 10 a.m. before Judge Washington. Bond will continue. Thank you. Court calls the case of the people versus Alan Payne.
Rest in loving the people.
Your Honor, so it's on behalf of Mr. Payne. You're up here. Alan Payne.
You're requesting an adjournment.
Yes, Your Honor.
How much time are you guys looking at?
The April 10th day was what was that, Bill?
Shouldn't have asked. April 10th, 2025, 9 a.m. I know you were surprised I even did.
Thank you, Your Honor.
Thank you. They're not up over. They're not there. Court does call the case of the people versus Kane Kellenberger.
Rest in loving the people.
Your Honor, Senator Bernstein with on behalf of Keith Kellenberger.
Your name, sir?
Okay, over. Your Honor, hoping for determination.
Probable cause conference will be adjourned April 3rd, 2025, 9 a.m. Bond continued. Court calls the case of the people versus Ashton Dew.
Rest in loving the people.
Your Honor, Bernstein on behalf of Mr. Dew, leading the way to the court. Ashton Dew. Your Honor, I have one epilogue from the discussion I had with Your Honor and Ms. Lonnie yesterday, which is
the probate attorney is going to make an amended order trying to see that. I offered the court suggestion and hopefully that will work out, so.
Okay. If from this court's perspective, if there's anything else that's needed, just get to us and we'll take care of it.
Thank you, and we certainly appreciate your honor's effort.
All right, and how much time are we gonna be looking
I
at?
should go that April 10th. I know, but you asked. That was what
Is this your last case?
it is.
Cool. World Cops Conference, April 10th, 2025, 9 a.m. Whereas your invite indicates bond will continue. Thank you, Mr. Simon. Have a good day.
You too.
This is another one. I believe it's right there.
They have them.
Yes.
Court calls case People versus Nicholas Elka.
Good morning, Your Honor. Katie Wisniewski for the people.
Good morning, Your Honor. Sam Bernstein, petition on behalf of Mr. Elka.
No, they don't. Hold on one moment. I don't know. I thought do they have it? It's longer than a second. I'm trying the patience thing. It's not working. No. Go ahead. Your name, sir? Thank you.
Your Honor, may we approach?
Fine. I wasn't objecting to you, it's him.
I appreciate that. And this morning, Your Honor, after further investigation and time spent in the file, it was the people's intention to dismiss count one and just proceed on count two spot.
Any objection?
No, Your Honor.
Count one is dismissed.
We're going to be waiving on count two.
All right. Sir, is that a correct statement? You're waiving your right to a preliminary examination on count two?
Yes, Your Honor.
All right. You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right. People also waive their right on that.
Me too, Your Honor.
All right. Preliminary examination having been waived as to count two, defendant is bound over on count two. Mr. Bernstein.
Your Honor, ask the court to please waive reading, enter a not guilty plea. And I'm in some technically information, but I will be.
All right. Defendant having waived formal reading, pleading not guilty, count two. Court will enter that plea. Pretrial will be set for
At 1:30 before Judge Convey.
April 1st, 2025, 1:30 Judge Convey.
Thank you, Your Honor.
Thank you, Your Honor. And as to the information, just to let the court know, we will have a new one prepared with just count two and have that file.
All right, very good. Thank you.
Thank
The other thing that you can do, counsel, if you want, is you can strike count one from that one, initial it, and then sign off on the one that's in there. Either way you want to do it.
Thank you.
Court calls the case of the People versus Mark Pettis.